Chapter 2, Statutes of Limitation Inapplicable to Express Trusts, 36 and 37 Vict. C. 66, Sect. 25, Subsect. 2. No claim of a STUEK trust against his trustee for any property held on an express trust, or in respect of any breach of trust, shall be held to be barred by any statute of limitations. This sub-section introduces no new rule of law, although it extends the former rule, i.e., the saving of express trusts contained in 3 and 4 will. 4, c. 27, s. 25, which was limited to land, including leaseholds and rent, to all kinds of property. Moreover, it does directly what the Act of William did in an oblique, cumbrous way. An express, or as it is sometimes termed a direct trust, is one declared by some written instrument, or in the case of personalty even by parole, and is not to be made out by circumstance or evidence, against his trustee, as the subsection is, substantially, a reenactment of Section 25 of 3 and 4 will. 4, c. 27, which section neither it nor the Limitations Act, 1874, repeal, further than they are inconsistent with it, and they do not appear to be inconsistent with it. As to the point now under consideration, it is necessary to consider Sect. 25 of the Act of William, which must be read with this subsection, and the previous law generally, STUEK Trust v. Purchaser of land or rent, where any land or rent shall be vested in a trustee upon any express trust, the right of the STUEK Trust, or any person claiming through him, to bring a suit against the trustee, or any person claiming through him, to recover such land or rent, shall be deemed to have first accrued, according to the meaning of this Act, at and not before the time at which such land or rent shall have been conveyed to a purchaser for a valuable consideration, and shall then be deemed to have accrued only as against such purchaser and any person claiming through him. The principal object of the above section being to declare that express trusts shall not be within it, the circuitous and anomalous model adopted for effectuating this simple object, and that, be it observed, only by implication is to declare that the right of the STUEK trust against his trustee shall be deemed to have accrued at, and not before, such and such a time, and then shall accrue in favor, not of such trustee but of another person. One would naturally have expected that, if the right against the trustee was not to accrue till a particular time, the Act would have gone on to say that after such time it should be held to accrue against him. Not a bit of it. The scene is suddenly changed. The section thenceforward becomes a purchaser's protection section, and he only is to be safe at the end of 20 years, and the trustee is left to the operation of the general law. The section of the Act of William relates only to purchasers for value with notice, and to land or rent, for purchasers for value without notice, at least if they had the legal title, which on a purchase from a trustee they generally had, and the possession of which, now that equitable titles are to be universally recognized, may be less material, and did not purchase from trustees of charities, were always safe, irrespectively of statute, as the favorites of equity, from its doctrine of notice. 2. STUEK Trust v. Purchaser of Personalty. 1. Choses in possession. Money and banknotes may not be followed into the hands of a purchaser to whom they have passed in circulation, unless he had notice of the trust. Other personal chattels can be recovered from a purchaser for value, semble, even if without notice, if he did not buy them in market overt. Market overt is, in London, strictly confined to shops in the city. The purchaser may be called to account by the STUEK Trust, notwithstanding his length of enjoyment, subject to the rules of equity against affording relief to staled mounts, or on grounds irrespective of the statutes of limitation. 2. Choses in action. A purchaser of a chose in action, whether with or without notice, takes it subject to the equities affecting it, and therefore to the claim of the STUEK Trust. But the protection of want of notice extends to a purchaser of a bill of exchange, and the same rule would seem to apply, as to the time within which STUEK Trust may sue him, as in choses in possession. In both classes of cases, i.e., of choses in action and in possession, it is apprehended length of enjoyment, as stated above, means the length of time prescribed by the statutes of limitation, that is, 6 years, if the remedy was in equity, by analogy to the legal remedy of detenue or trava, in the case of choses in possession, or 6 or 20 years in the case of choses in action, if they be debts, according as they are simple contract or specialty. 3. STATUTES Trust v. Trustee and volunteers from him. 1. As against the trustee in possession, or volunteers from him with or without notice in possession, of land. STATUTES Trust may follow the land in their hands, without limit as to time, subject to the rules in equity, irrespective of the statutes of limitation. By following the land is meant claiming to have the trusts of it performed. 2. As against the trustee not in possession, having wrongfully aliened land to a purchaser, with or without notice, or to a volunteer, with or without notice, subject to the rules of equity, irrespective of the statutes of limitation. The STATUTES Trust may I compel him to purchase other lands of equal value to be settled on the like trusts. 2. Take the sale monies, if any, with interest. 3. Have the present estimated value of the lands, allowing for any increase of price caused by improvements subsequent to the alienation. 3. As to any property subject to the rules of equity irrespective of the statutes of limitation, STATUTES Trust may have I account from the trustee, if the property is capable of account. 2. Delivery by the trustee, or what is tantamount thereto, if possible, and improperly withheld. 3. Compensation from trustee personally for any loss the trust estate has sustained by any breach of trust. 4. If the trustee, with intent to defraud, convert or appropriate the property to his own use, or dispose of or destroy it, he is liable to 3 years penal servitude or fine, or 2 years imprisonment, with or without hard labor. B. Held on an express trust. Implied and constructive trusts were never accepted out of the statute of will. 4. And the plea of lapse of time, whether the statutory period or less, is more readily admitted when put in by such trustees, their position being usually, to a certain extent, adverse to the STATUTES Trust. Implied trusts have been well defined, as those presumed from the intention of the parties and nature of the instrument, and as otherwise known as resulting or presumptive. Constructive trusts, as those raised by the construction of a court of equity, where the legal owner cannot also enjoy the beneficial interest without violating some principle of equity. But, these distinctions carrying us back to the somewhat interminable further questions: when and where are such principles violated, what are those principles, when and where and how are the intentions of parties and the nature of the instrument to be ascertained? The best definition of constructive and implied trusts for our present purpose is, perhaps, the simple one, such as are not express, as defined above, c. or in respect of any breach of such trust, as there can be no rightful claim against a trustee without some violation of duty, i.e., without some breach of trust. These words seem superfluous, and hardly to carry the sub-section further than it would have been carried without them. Before 36 and 37 Vict. Breaches of express trust were not within any statute of limitations, although equity adopted fully the analogy of the statutes, and refused relief to a party who lay by long after notice of a breach of trust. And the same rule has been applied against the personal representative of a deceased express trustee who has committed a breach of trust. When, therefore, a breach of trust is called, as it is, a debt, it is only so sub modo, and for some purposes, e.g., in the administration of assets, for were it so absolutely, it would be within the statutes of limitation, which concern debts, and nowhere expressly except breaches of trust. Their exemption, therefore, was under the general principles of equity. As implied and constructive trusts themselves were not accepted out of any statute of limitations, and are not now, so neither were, nor are, breaches of them. D. Shall be held to be barred by any statute of limitations. The statutes of limitation are, 21 Jack. 1, c. 15, 3 and 4 will. 4, cc. 27, 42, and, after January 1, 1879, 37 and 38 Vict. c. 57. The last named Act, if it continues law, will have an important bearing on the subsection under consideration. and will, it may be contended, make time run in favor of an express trustee, or at least against land subject to the trusts within it, notwithstanding 36 and 37 Vict. C. 66, for it enacts that no action, suit or other proceeding shall, after January 1, 1879, be brought to recover any sum of money, or legacy charged upon, or payable out of, land or rent, secured by express trust, or any arrears of rent or any interest in respect thereof, except within the time within which the same would be recoverable if there were no such trusts. The subsection leaves open to the trustee all modes of defense, other than the statutes, which were open to him before. These are, 1. Acquiescence, 2. Waiver, 3. Staleness of demands, 4. Laches. I. Acquiescence. Acquiescence is either direct, as where one now complains of an act, which he fully knew, and expressly approved of, or indirect, as where one having a right to property stands by, and sees another dealing with it in a way inconsistent with such right, and makes no objection, while such dealing is in progress. The court will not visit a trustee with the consequences of a breach of trust committed without the sanction or direction of the STUEK trust, if, when it comes to his knowledge, he has acquiesced, and obtained the benefit of it, for a long period. Length of time, where it does not operate as a statutory or positive bar, operates only as evidence of acquiescence. A bar by acquiescence involves lapse of time, and a bar by both are not two, but one, and the same, proposition. A reversioner may acquiesce in a breach of trust before his interest comes into possession, though time does not run against him, nor is he bound to assert his title. Till then, the decision last referred to must be considered as qualifying Mr. Hill's observation, that the acquiescence of a STUEK trust in remainder will not be binding on him during the continuance of the preceding life estate, for, until his own title accrues in possession, he has no immediate right to interfere in the administration of the estate. The authority cited by Mr. Hill for this position was a peculiar case standing on its own rights. It would seem then, as if acquiescence might be a bar within the statutory period, even in express trusts. The equitable doctrine of acquiescence has a statutory validity given it, for the act of will. For provides, and the provision is not one of those prospectively repealed by the Limitations Act, 1874, that nothing in this Act, 3 and 4 will. 4, c. 27, shall be deemed to interfere with any rule or jurisdiction of courts of equity in refusing relief, on the ground of acquiescence or otherwise, to any person whose right to bring a suit may not be barred by virtue of this Act. 2. Waiver, of which it has been said, that it is difficult to know what its legal effect is, and that it is not to be confounded with acquiescence. A mere waiver signifies nothing more than an expression of intention not to insist upon the right in question, and will not in equity bar that right without some consideration of money or money's worth. Unlike acquiescence, it seems not, necessarily, to involve time. 3. Staleness of demands. Though no time runs as between STUEK trust and trustee in express trusts, so as to bar the remedy of the beneficiary, yet, with respect to claims made by him against his trustee, the general rule of equity that encouragement is not to be given to stale demands is equally applicable, in those as in other cases. The rule was thus laid down by Lord Camden, a court of equity, which is never active against conscience or public convenience, has always refused its aid to stale demands, where the party has slept on his right, and acquiesced for a great length of time. It is not easy to see what this rule exactly amounts to. Staleness involves time. Does the rule mean that it does not begin to tell in favor of the trustee until after the statutory period, in the case of land 20 years, as the law now is, or in the case of chattels personal 6 years, but that it then begins to be imputed against the STUEK trust, although the trust may be then still subsisting? 4. Laches. This also involves time, the mere lapse of which, or delay ensuing, it has been said, per se, disentitles a party in certain cases, e.g., purchases by trustees and other constructive trusts, where laches for less than the statutory period will bar. But, generally, mere lapse of time is no bar, though an ingredient, with other circumstances, for drawing inferences unfavorable to one who has lain by, in the case of land, 20 or nearly 20 years. Public convenience has been suggested as the ground for holding lackeys at bar. If so, the legislature having prescribed the shortest time within which the public will suffer inconvenience, lackeys for a shorter time than that statutory period would appear, in the case of express trusts, not to operate as a bar. Beyond the statutory period, however, it would begin to tell. The distinction between lackeys, staleness and acquiescence would seem to be, that lackeys implies lapse of time, accompanied with negligence more or less crasser, that staleness implies time only, mere lapse of time not necessarily implying negligence, and that time very considerable, whilst acquiescence imports, in addition to time, an active concurrence of the will in the thing complained of.